Thank you, President. I rise today to speak on the Bail Amendment Bill. This is an important piece of legislation. Its purpose is to address and solve the problems with the current bail laws while ensuring there remains a focus on the community safety, particularly on those accused of committing various serious offences and those who could pose an unacceptable risk to the wider community. President, the point of the modern justice system is to ensure that we do not see repeat offenders continue to put other people or themselves at risk. And part of this is addressing that dramatic increase in the use of remand, which has manifested in a disproportionate impact on current bail laws, harming vulnerables and disadvantaged communities. And of course, as we do with all good pieces of legislation from this side of the chamber, we address gaps in the current legislation through procedural and technical amendments. President, I commend the work of the Attorney-General, Attorney Symes, her team and the Department of Justice on this work. These reforms are designed to make Victoria a safer state, and individuals who have been proven to have no regard for the continued safety of the community will in turn be dealt with appropriately. To that effect, alterations to the laws must be made. Some history on the bill would be appropriate before getting into the substance of the bill. In 2018, there was an introduction of several bail reforms in response to the trend of perpetrators out on bail breaching their bail requirements and then committing violent crime and dangerous crimes. The most infamous of these offences being the Berger Street massacre. The attack was deliberate and undeniably evil. In the wake of the Berger Street massacre, it was clear that the action needed to be taken to prevent something like that was happening again. An inquiry headed by Justice Paul Coghlan was conducted into any improvements to be made in the Victorian bail laws that could prevent reoffences during the bail period. The legislative solution that was found was to introduce a reverse onus bail test on a lot more offences, meaning that the accused must prove that there is a compelling reason for bail to be granted. In addition to this, senior police officers were given powers to remand an individual for up to 48 hours up until there is a court available to hear and judge their bail application. This was intended to solely target serious offences, restore public's confidence in all Victorian bail systems and increase community safety. President, our laws must be designed to ensure something like this never happens again. That is clear. Victorians need a legal system that is tough on crime. We should all feel safe living in a state with zero tolerance policy for reoffending. It should be a comfort to know that your police force is equipped to protect you against the few individuals that seek to undermine the safety of the community. But for different groups in Victoria, the harsh nature of these bail laws is not a comfort or cause to feel protected. Unfortunately, there has been an unforeseen consequence to these harsh bail laws. Without sugarcoating, some of the most vulnerable groups of Victorians have been disproportionately disadvantaged by these bail laws. The most concerning is the statistics attached to the remand and incarceration of Aboriginal women, which has over recent years doubled. This was highlighted earlier this year by the coroner's report in the tragic death of Veronica Nelson after she was held in the remand for shoplifting. The coroner's report into Veronica Nelson's death found that it was an unacceptable outcome and highlighted just how important it was to get these bail reforms right and foolproof. It has been a long process of the community and stakeholder consultation to ensure that this bill gets it right. Nelson's death was a harsh reminder that it needs to be done. Something must be done to rectify the impact that bail laws were having on disadvantaged communities and minor offenders and make Victoria a safer and fairer place. We should be a state that has zero tolerance for crime, but we shouldn't be a state that traumatises individuals before they have been proven guilty. But another way that this bill addresses misjustice is in relation to the reverse onus bail test. Under the bill's amendments, the principal act, the erroneous process of targeting only serious and violent offenders to ensure those accused of relatively minor charges do not find themselves unnecessarily being subjected to the high bail standard we have in Victoria. Additionally, the bail bill will refine and clarify the definition of unacceptable risk. Under the new definition, it will be clear and evident that the potential risk of committing a minor offence does not satisfy reason to refuse bail alone. Bail refusal must only be issued if there is a potential risk of causing harm or threat to someone's safety or welfare. This may also be some very exceptional cases extend to property crime, but only in a scenario that it affects welfare. These amendments will also repeal sections of the Bail Act relating to bail-related offences, specifically the breaching of bail conditions and committing of further offences whilst on bail. That is not to say that breaching bail conditions will no longer lead to adverse consequences for the offender. It simply will no longer exist in Victorian law as a standalone offence. If an accused was to breach their bail conditions, they would see consequences like having their bail revoked. Materially, the outcome would be the same. The next reform is the introduction of the remand prohibited offences. This means that the specific offences within the Summary Offences Act are extremely unlikely to result in a prison sentence, will no longer enable or justify an accused to be put into remand. Of course, individuals accused of prohibited offences will still have to apply for bail and be subject to the bail conditions set out by the courts to ensure that community safety is upheld. The next amendment will reform the Bail Act to allow persons who have had their bail application rejected to make a second application without having to add new factors or circumstances to their case. This is to prevent and discourage, by way of removing incentive, individuals appearing without legal representation for their first bail application with the purpose of ensuring that they will receive a second bail application. If an individual believes they have wrongly been judged, they should, in principle, have the right to appeal. Of course, exceptions will be made in the likely but all too possible situation that certain crimes of very high severity are committed, such as terrorism or homicide. President, as we do with all pieces of legislation that we draft, we have consulted widely. That includes across all government, members of parliament, with the courts, the wider justice system, Victorian Legal Aid and the Criminal Bar Association, the Office of Public Prosecutions, Victims of Crime Commission, the Federation of Community and Legal Centres and the Victorian Equal Opportunity and Human Rights Commission. We've also consulted with the Aboriginal Justice Caucus, the Law Institute of Victoria and the Police Association of Victoria, the Commission for Children and Young People and the Victorian Aboriginal Legal Services. The Attorney has long flagged the need for reform, and in fact, in March this year, the Attorney announced that our bail laws would be reformed, with a particular focus on addressing the changes that were brought in 2018 and their disproportionate impact on Aboriginal people and other vulnerable people. It is also important to acknowledge that for a lot of communities, crime is a very complex issue that warrants a holistic approach. This means that bail laws are not the be-all and end-all to the issues of crime and high incarceration rates, nor will conditions that lead to high incarceration rates result in a safer Victoria. Instead, it is important for our justice system to focus on rehabilitation. The Allan Labor government has attempted to contribute to and assist in supporting and creating a preventative approach to crime as opposed to a traditional punitive measures we have seen in the past. This is done in several specific ways, but the overarching concept behind the approach to preventing crime communities that experience higher rates of incarceration is identifying the root cause of criminal activity. It is often a lot more complicated than negligence or malice. Quality of life is a big factor in motivating crime, as are crimes of despair. And we know that education is a way out. Programs like Free TAFE that offer young people enrichment, education and employability that brings positive changes to lives of our First Nations Victorians and those marginalised communities are vital. Much focus has been placed on our big build projects to ensure that employing First Nations labourers and apprentices, giving First Nations Victorians employment opportunities is a key to addressing economic disparity. It doesn't begin and end with bail laws. But the data shows that the introduction of the 2 bail breach offences in 2013 have made a substantive contribution to the significant increase in Victoria's remand population, with a particular impact on women, as well as First Nations people and those experiencing disadvantage. In fact, in 2019, Crime Statistics Agency Characteristics and Offending of Women in Prisons report found that proportion of remanded women who faced a reverse onus bail test increased from 37% in 2012 to 79% in 2018. and 29% of women remanded in 2018 faced a reverse onus test only because of these two new offences. While this clearly demonstrates that these offences have increased remand, it is far less evident that the offences do anything to discourage bail breaches. Our criminal justice system already provides an appropriate bail response to bail breaches and offending whilst on bail, and these offences are not necessary to achieve that end. This bill is about making sure that the consequences of offending are reasonable and proportional. The holistic approach will yield the best opportunity and the best good for the community. It will keep people out of jails and make them productive members of society and bring an immense degree of improvement to their own lives. To wrap up, the bill implements 8 to 13 recommendations and the Nelson Inquiry relating to the Bill Act. It also introduces several changes to existing features of the original legislation Bail Act. It repeals the 2013 Bail Act offences and breaching bail conditions and committing further offences whilst on bail. But make no mistake, this conduct will still have consequences, but no longer standalone offences. The bill also makes further amendments to clarify and modernise and otherwise improve the Act. Under the current law, an accused cannot make a second application for bail without demonstrating new facts or circumstances have arisen since bail was refused or revoked, or they were not legally represented at their first hearing. In practice, this has accused people of making self-represented applications on the advice of their lawyers, out of a concern that they will exclude them from making a better, well-prepared application with more time. This contributes to a high number of short-end remands in the system and is the issue the coroner has pointed to needing to be addressed following the death of Veronica Nelson. The Bail Amendment Bill will also allow an accused person to make a second legally represented bail application before the court without having established new facts or circumstances, with the aim of reducing unnecessary short stays in remand. Applications and unrepresented people at the time consuming the court's time making an application without legal representation or making application because they don't feel they have to do it on their own results in people who may otherwise obtain bail being subject to the short remand. This is highly disruptive to a person's life, their housing, parenting responsibilities, employment, and short remands are highly disruptive to our prison system. This reform will encourage an accused person to make legal representation application at the earliest opportunity, as there is no longer to be a concern about meeting the new facts or circumstances test in order to make second legally represented application. Part of the role as a Member of Parliament is to reflect on the views of our community, and we are democratically elected after all, and the importance of this is to ensure that our laws keep up to date with the changing views of our society. I look forward to the opposition joining us in the support of this bill, and I understand they are broadly in support of our work. Thank you.